We wait.
This announcement of the new EMFA talks. Yeah.
Yes, so good morning, everyone, and thank you for connecting today for this new series of EMFA talks. I think that the events that we organized last academic year before the summer break were somehow useful and interesting and received a lot of attention. So considering that now the European Media Freedom Act is operative, we decide after, the 8th of August, we decided to start again with a new series of EMFA talks in order to understand how the implementation of the Act is working. So we start today with Article 22, also because of some cases somehow that anticipated a little bit the implementation of this article, and but we will continue with other events once per month. We decided to have this event once per month, but we will keep following the European Media Freedom Act and try also to boost the interpretation and the analysis of the Act through our observatory. So please feel free to send us your contributions in case you want to publish on our website. And so without further ado, I give the floor to Pierluigi for this new EMFA talk series, to start this new EMFA talk series with the discussion on Article 22. And welcome, Riccardo. Now the panel is completed. Thank you very much, everyone, for being so numerous today to our event. Thanks.
Okay, well, thank you, Elda. Thank you, everybody, for being here. We start this new series of the EMFA talk discussing Article 22. Article 22, as we know, is an attempt by the European Media Freedom Act to intervene on a long discussed and controversial issue that is what happens when there are mergers in the media sector. These mergers are mergers like others, or they need a special treatment. And the article gives an answer to this question, and the answer is that member states shall lay down in national law substantive and procedural rules which allow for the assessment of media market concentration that could have a significant impact on media pluralism and editorial independence. So the idea is that there is this media market plurality test that is to be based on the recognition that there is a special attention to media plurality and media pluralism and editorial independence. This means that, as we know, the European Union has a strong merger test that is a competition law concentrate on mergers for now many decades, but this law is judging that that wasn't insufficient. The fact that it was insufficient is in reality, and is also in the numbers and the studies that we have done for many years for the Media Pluralism Monitor, that showed that in reality, many states maintain specific laws and specific regulations for media in the case of mergers, but these rules were very obsolete, very different, and were present in more or less half of the states. So this created a fragmentation of the single market that was avoidable and ineffective. The fact that another half of the states didn't have anything similar and were left only to the protection of the competition law also created a gap between these two kinds of protection, one old for probably inefficient and the other absent, and the old blanket was the competition law intervention. This situation that has been there for decades has been relatively aggravated by the change brought by the digitalization and by the arrival of platforms as gatekeepers in a sense, but also as doors for the media information in many cases, and also from the reaction of the media world to this, because the arrival of platforms and the diminishing of advertising and subscription and newspaper buying and so on, all the revenues were really put in jeopardy during this last decades, created a sort of permanent economic crisis of legacy media, and one of the answers was concentration. One of the attempts of answer was more concentration. And this happened in a sector that we know was already concentrated from the start, particularly in the area of television, but not only. So we have seen with the Media Pluralism Monitor an increase in concentration that reached levels very, very high. And by the way, when the digital world arrived, this didn't lower concentration even in the digital world and this activity of distribution of news, because even in digital we have very high level of concentration. So one can say that this Article 22 is trying to give an answer, a very partial one, to an area of increasing concern. Fragmentation of the single market and increasing concentration in the legacy media and present concentration in the platforms world. What is the direction that the article gives for this? Well, the article is relatively balanced in saying we have to look at these two elements and there should be an explicit control by the states. The article, however, says are the states that should design this control. And so as being a regulation, but being a regulation of principle, as in other cases, this leaves to the states the necessity to act. And so we will have to see also how this will bring what the article really is requiring, that is more uniformity in the single market and in the European Union. On the other hand, the article gives also some direction by indicating that editorial independence is a key element, media pluralism and editorial independence. So somehow, also for situations in which the concentration is economically unavoidable for question of sustainability, the article seems to give a way out through a recognition and defense ex post of the editorial independence. So it's a sort of indication also in the article of possible remedies and a new direction for remedies. Remedies that looks more substantial than behavioral remedies, with an idea that is something in the middle between behavioral and structural remedies, and is something that has to evolve as an idea and as a concept as the article will be applied. What are the major issues, at least in my opinion? One major issue is that the world, as we said, is the media world is very concentrated, even behind the outside the media phenomenon. And this obviously a media plurality test cannot do anything about this. But does something in putting the topic at the center of the discussion, and so maybe it opens also a reflection about the possibility of different and further intervention later on. And this is probably the principal contribution that this article is giving. And then, as I say, the other element is this particular attention to editorial independence, and that is, as I say, a possible way out also for situation of already existing concentration. So from this article, from the evolution of this article, could also come some indication of what can be done also in situations that are particularly already difficult and of too limited pluralism. But however, I wanted just to introduce the topic very quickly, and we have great speakers that can tell us much more, and also can concentrate, because the article is there now for a while, on the possible already the first evolution that we are seeing in the States, and also the first cases of media mergers that came in the meantime, and obviously open the question of what is happening while the article is already in place, but maybe is not yet operative or fully operative in the States. So my proposal is we proceed with our four speakers in the order I have them here. Ricardo Gutierrez, Maria Luisa Stasi, Frederic Bokobza, and Malgorzata Kozak. I propose that they speak 5 to 7 minutes, as they 10 minutes as they prefer, and that we have the possibility to take questions and to discuss among themselves also later on with the second round or something similar. I would start from Ricardo Gutierrez of the European Federation of Journalists. Ricardo, you have the floor.
Thank you, Pierluigi, and thank you, Elda, for the introduction. Thank you for giving me the opportunity to share the views of journalist organizations on Article 22. You know that the EFJ is representing journalist organizations in Europe. And as you know, for journalists and for their representative organizations, mergers in the media sectors always mean restructuring in newsrooms, downsizing of editorial teams, sharing of content, what we call the editorial synergies that usually impoverish and standardize the information on offer, dilute the identity of media outlets, and erode pluralism. In short, what may be considered from a strictly economic point of view as a strategic consolidation generally manifests itself in a social bloodbath in newsrooms and a decline in pluralism. From a labor point of view, freelance journalists are always the first victims of these mergers. But the big loser is also the citizen, I mean, through the reduction of editorial content. Journalists, therefore, and journalist organizations, therefore, welcome the provisions, the partial provisions, as you said, introduced by Article 22 of the EMFA, even if we consider it insufficient. I will begin by saying something positive about the reform, which of course has its good points, and I would like to thank all those who fought for these positive developments, particularly the academic community. Positive point, you mentioned it, harmonization of anti-concentration rules across the European Union. The media market is not limited to national borders. All major media groups operate in several countries, and it was only natural, I would say, to develop legislation common to all member states. Another positive point, the new rules introduced by Article 22 apply to all media, all formats, print, audiovisual, online. This is an important step as well. You know that in some countries, like Germany, certain antitrust provisions applied only to certain formats. And we all know that this distinction made no sense. Now, allow me to make more critical comments. First, we would have hoped for more coercive rules. given the scale of the challenge in terms of media concentration. You know it, the latest edition of the Media Pluralism Monitor clearly shows that the 32 countries analyzed are all at risk or high risk with regard to the criterion of plurality of media providers. The map of Europe is totally red, without exception. And some countries are showing very worrying levels of risk, 96% of risk in Lithuania, 95% in Belgium. So in our view, Article 22 does not take sufficient account of the seriousness of the situation. We believe that in the face of such a dramatic situation, the European Union could have imposed stricter, more coercive rules. The second point of dissatisfaction is and you also mentioned it, Pierluigi, the uncertainty surrounding how the new rules will be implemented in light of the guidelines drawn up by the Media Board and the European Commission. I had the opportunity to discuss this with officials from the Federal Competition Authority in Belgium and the public media regulator in Belgium. They are really waiting for clarification on the practical consequences of Article 22 at the national level. Of course, they understand the spirit of the new rules and they share the objective of the new rules, but they do not yet see how these rules will be put into practice. They are already identifying areas of uncertainty. However, I was really pleasantly surprised by their willingness to cooperate. I believe that regulators, media regulators and competition authorities are allies. They understand that the European regulation strengthens their role and they very much welcome the idea that preserving media pluralism, including editorial independence, as you mentioned, must be a key factor in their assessment. Third reason of dissatisfaction, it relates to, I would say, the limited scope of Article 22, which mainly concern mergers between media service providers. Article 22 remains silent on the overall structure of the media ecosystem, which is facing concentration and market dominance that are particularly worrying for pluralism, but also for democracy. This was the reaction of the Dutch Federation of Journalists, the NVJ, following the announcement of the Dutch Competition Authority's approval for the merger between DPG Media and RTL Netherlands. As you know, the Dutch authority, the ACM, gave its green light to this merger by the end of June. It imposed rather interesting conditions with a view to preserving the identity and editorial independence of the titles involved in the merger. DPJ Media, which already acquired a number of local media outlets in 2015, is becoming virtually monopolistic in the Netherlands. They control 90% of the Dutch print media audience. The NVJ, the Dutch Association of Journalists, fears an automatic negative effect on journalists, particularly freelancers who are likely to see their fees reduced without, in that new framework, without any real bargaining power, as there is virtually no competition left. But it's interesting to note that the NVJ has more than just this concern. It wonders why the ACM, the regulator, says nothing about the effect on the media market of the ultra domination of large digital platforms and AI operators. It seems like an entire section of the European media ecosystem has been completely overlooked, I would say, by Article 22. It is clear that the concentration of large, very large platforms which control the structure of information dissemination and even the generation of information through their alliances with artificial intelligence operators, this has a decisive impact on media pluralism in Europe. Of course, other European rules apply to these big digital platforms, DSA and others, but the EMFA regulation ignores the problem posed by the concentration of big tech and its, I would say, its editorial influence. Just look at how Elon Musk has transformed social media, social network X into a vehicle for disseminating his political ideas. Fourth and last point of dissatisfaction, I would say the lack of European measures to protect the most vulnerable operators, the local and regional press. In this regard, I would like to conclude by calling on those gathered today to pay close attention to developments in Belgium, in French-speaking Belgium. As you know, the dominant group in the French-speaking daily press, Rossel, is preparing to absorb the minority group, IPM. We are therefore moving forwards towards a monopoly in daily newspaper publishing in French-speaking Belgium. The two press groups concerned make no secret of the fact that one of their objectives is to rationalize their local titles, which are nowadays competitors at local level. Sudinfo on the Rossel side and L'Avenir on the IPM side. The pure liquidation of L'Avenir is expected with dozens of job losses, but above all, the end of pluralism at the local level. There will be only one local daily newspaper covering the news in Wallonia. And to make matters even more worrying, the French-speaking government has just announced in Belgium the closure of 4 of the 11 local television stations in Wallonia for financial reasons. That means that EMFA regulation does not prevent these harmful developments. And this confirms my belief, the belief of journalist organization that Article 22 is a step in the right direction, of course, but that it is far from sufficient, I would say, to prevent media concentration, let alone prevent the ultra-domination of big tech and its impact on the European media ecosystem. Thank you for your attention.
Thank you, Riccardo. Only one thing, you mentioned the remedies, that something of interesting was somehow in the remedies. I have 2 questions on this, on the Dutch case. First, there was any influence except for the competition authority from other media authorities or other authorities during the discussion that you are aware of? And second, what is this possible positive element you saw in the remedies?
So the Dutch regulator imposed the creation of independent foundations protecting the independence of any title involved in the merger, which is a kind of it's a way to protect by an independent body or so-called independent body, because I must confess that the NVJ, the Dutch Association of Journalists, they have some concerns about who will be nominated to be part of these bodies. But at least the regulator thought about structural changes, or they imposed structural changes to the merger in order to protect the independence of each title, which is a good step. Now we are all waiting for the implementation and the way these foundations, for example, there are also protections regarding or provisions regarding the need to maintain editorial staff and so on. So they took a range of decisions in the right direction with the aim of protecting editorial independence of all these titles. involved.
And do you think Article 22 was instrumental in this?
I think when I discuss with the regulators, they all know about EMFA. They have doubts about the implementation of EMFA, but they know that EMFA is a new, I would say, is the new standard at European level. So they are implementing the spirit of EMFA, even if they don't have the guidelines on how to do it. So it was very clear from my discussion with the colleagues in the Netherlands and in Belgium. And in Belgium, I discussed it directly with the regulators and the competition authority. I was, invited to a hearing about the merger, and for 3 hours we discussed the need to protect editorial independence. So I really believe that they integrated, the spirit of EMFA. Now, as I said, is it enough? We also face, as journalist organizations, we need to protect the existence of all these media. And sometimes we will accept a merger because it's the only way to save. In the case of Belgium, there will be, a total collapse of IPM Group and all the titles if there is no merger. So, and I believe the regulators and the competition authorities are in the same framework as we are. So, how to maintain, a minimum of media pluralism when you know that if you refuse the merger, then it will be worse because one of the groups will totally collapse and titles will disappear and jobs will disappear as well. So it's, I think it may explain maybe the soft approach from these regulators. As a journalist representative, I understand it as well.
Thank you, Riccardo. Thank you. We move to Maria Luisa Stasi. Maria Luisa, on Article 19.
Sorry, it took me a while to unmute myself. Can you hear me?
Yes.
Excellent. Morning, everyone. And indeed, thank you, Pierluigi, Elda, Roberta, and the CMPF team for this invitation. I was indeed missing the EMFA talk after last season, so I'm glad to see them kicking off again. What I'm going to try to do is, because I know that there are other people that will delve into specific cases, and perhaps we can get a little bit of a focus on those later on. And in this few minutes, I'll just try to somehow zoom out a little bit and focus on the interplay or the interaction between this new media plurality test and the merger rules, or competition rules more in general. And specifically, I'm going to try to offer 2 sets of considerations. By no means they're no answers, but I think they could be good reflection points to be taken into account as we go, because overall this is already clear to me from what Pierluigi and Riccardo already said. It is a learning process. We need to sort of see where we go and refine and fine tune. And we have 27 case studies to look at, so we won't miss materials. But it's definitely, I think, one of the worst things we can do is to start off with already a set of precise and specific answers to a problem that is indeed way more complex. So I'm gonna try to sort of offer some some reflection points on 2 main issues. The first one is, now we have the EMFA, and obviously it has a specific goal and is a positive. I agree with Riccardo, is a positive and welcomed, with Riccardo many more, a welcome step. Might not be the only one we need, but does it reinforce or does it eliminate the merger role in protecting media plurality? Because in a way, we might be arguing, how much that is true. But in a way, at least some of us were very convinced that merger rules do protect media plurality, or should protect media plurality. Definitely, there is way more consensus about the fact that these rules and this set of rules, they should protect cultural diversity in Europe. And to what extent cultural diversity means media diversity can be debated, but definitely it's not the first time that we have these conversations. I remember, for example, this conversation being pretty vocal, journalists being pretty vocal also in this specific angle when it was about the Polska Press merger in Poland a few years ago, with the conversation of, for example, using the Article 4 of the Treaty of the European Union and the obligation of sincere cooperation between member states in combination with the Charter of Fundamental Rights and Article 11 that protects media freedom, to say, well, member states, when they apply European law, they need to do that, having a look at the value of the treaty. And one of them is definitely media diversity. So it doesn't happen in a vacuum. It was there. The point is, it's going to reinforce or it's going to eliminate, because we have a sort of a lex specialis. I have my own approach to that, and I think it would be much better to complement and reinforce for a number of reasons. But it seems to me that the European Commission is still a little bit wondering, and the signals of this is that we know that the European Commission has opened recently consultation on their merger guidelines, and it's meaningful, or at least I found it meaningful, that there are some questions in this consultation about diversity as a criteria to be considered in the assessment of mergers, but also the European Commission has already organized or put the date for some workshops to discuss the new merger guidelines, and the title of one of them is the foundation of our democracy. When can merger control protect media plurality? So this is, to me, a confirmation that we are actually still looking at this from the two sides. National authorities, they will come with their own position. The ACM has been already mentioned. Obviously, they do have their own strong position on whether where this relation is going to go. But it's one out of 27 member states, so this is going to be interesting to look at the national implementations. My main point, or one of my main points, is that I do believe that the margin of maneuver that is going to be left to these two sets of rules depends very much about how widely we're going to implement the EMFA. Ricardo already mentioned and said, well, it might be a little bit limited because there are other actors. We've spoken about the platforms or AI providers. So there are other actors there that they have a massive impact on how much plurality we have at the media in the media environment. So it really depends if we're going to narrowly interpret the EMFA and consider media mergers, a limited set of operations or not. I think it's not coincidence again that if we look at the work plan of the board, the guidelines to clarify for which specific operation Article 22.4 and Article 23 needs to apply. That's one of the main points. We definitely need to avoid conflicting decisions when it comes to the upstream market or the aftermarkets or other related markets. So hence what we're talking about, AI systems or even cloud providers. So, the kind of dependencies, vertical dependencies that we have there, they will play a role, and it will be very difficult to manage completely different scenarios in terms of plurality and diversity at those different levels of the vertical infrastructure, let's say. So all these are lively topics. They will interact to each other in different ways. As I said, I don't think it's time for definitive answers, but we need to look at all this. I do see the EMFA as a very lex specialis in comparison to the merger rules, but I'd also believe that there is an extremely important role for the merger rules to keep on playing, because the environment that we're looking at, it goes well beyond what I think is the scope of application of the EMFA. I'll elaborate a little bit more on the second point. The second point is, regardless of merger rules or EMFA, there will be a sort of a cross-pollination in between these two, and specifically when it comes not necessarily to the issue of independence or editorial independence, because that's very much for the media sector. But there is one concept which is diversity and plurality, which is across the two sectors already. It just probably has been interpreted in a different way, but I have seen that with the digitalization, when we talk about the markets, we increasingly talk about a diversity and a multiplicity of actors, and not only a quantitative assessment of how many actors are there. The competition analysis is focusing way more, increasingly more, moving from the assessment of a specific behavior to the assessment of a specific business model. And this necessarily tells us way more about how many players are there and which players are there in the market. So I do see this shift on diversity. For example, a concrete example, all this discussion about breakup calls in specific sectors and the pushback on breakup calls. One of these pushback that I find interesting in this specific conversation we're having today is that some argue that even if we break up Google as a search engine, then we run the risk of having a new player that is going to replicate exactly the same business model. And then in 5 years' time or 3 years' time or 2 years' time, we're going to be again in the same situation. We're just going to call it differently. The dominant player will be called differently. So the point is how to recreate an environment that will deliver a different output rather than breaking up the existing players and going there with the same value extraction model. To me, the point is how to create the incentives, but maybe the EMFA and the way the attention to diversity can be one of the instruments to be used also here. I see this trend also in the DMA, the Digital Markets Act. I think it's certainly a move in that direction, not only because it's an ex-ante intervention, but also because the objectives, the fairness and contestability, which basically means we need to have guarantee market entry and guarantee choice. To me, they are absolutely intrinsically linked to diversity player and not just sort of a quantitative assessment there as well, but very much a qualitative one. More specific, I mentioned the merger guidelines. I think there is margin and there is a momentum to sort of rethink some specific benchmark that we have used in the competition analysis for market concentration. Traditionally, the HHI test has been used, which tells a lot about, how many players are there and how concentrated the market is, but it says zero about market diversity. It says zero about it tells us if we pass from 4 to 5 players, if this is gonna change a lot in the competition dynamics, but it doesn't tell us anything if we're gonna eliminate the only really diverse player there, and then the other 4 that are left are exactly the same and replicate the same kind of business model. So basically, the existing benchmarks, they say very little about the diversity of the value chain, of the output, user preferences, choices, etc. And I see this increasingly important. I think it has always been. But if you think about the big picture and all the discussion we are having today in Europe about digital sovereignty and building an alternative infrastructure and so on and so forth, so we're definitely trying to create diversity there, not just an alternative player that is exactly the same. So I see all this sort of conflating in the same pitch for a nice game. I do believe that also there is an absolute need for alignment in between EMFA and the competition rules, being these mergers, the DMA, or the competition assessment of certain behaviors. Having conflicting decisions in the upstream or after market or related markets within those ecosystems will be a massive problem and a mistake, I think, will slow down our path towards the objectives that the EMFA is trying to guarantee. Ricardo has mentioned already the AI. I mentioned briefly cloud computing. I think it's we are in a phase where finally we're trying to raise the attention on the fact that the the economic dependency is also an infrastructural dependency, because many of these local players, they had to sort of get into the digital world and change the way they produce news, change their output, the production process and their outputs, because the content needs to be ready for being distributed on other platforms and so on and so forth. So this is a clear example of conflating the traditional competition analysis and this diversity. And I think we need to find a way for the different authorities to have a look at the same picture, even if coming up from different angles. And then, so my best scenario there would be a cross-pollination, as I said at the beginning. But we'll see. We need to sort of deal with also some cultural resistances that are different in the different 27 member states. It's encouraging, I think, that the EMFA, that the board already in its work plan is thinking about a point of contact for cooperation with different organizations. The wording in the work plan is about enhancing knowledge sharing, aligning regulatory practices, and so on and so forth. Nothing new in regulatory dynamics. We have seen this kind of language in the past, but probably if applied concretely to these specific issues, it will help to sort of overtake this cultural resistance and create a true harmonization. I hope that the academia, the journalists and civil society can contribute to this kind of effort as well. And probably we can sort of get to the point in less than a decade, possibly, because that would be a severe problem for the increased concentration in the market that we all said. I stop here for the moment, and I'm happy to sort of elaborate a little bit more later on. Thanks.
Thank you, Maria Luisa. One point I wanted to underline of your speech or ask you. There is an angle of the lex specialis that I like of the EMFA and of Article 22. And is this the implicit idea or the explicit idea that in the media sector competition protection is insufficient? And the reason why I like this is because I find it as a possibility for starting looking at the situation of extreme concentration outside of the merger world, situation already existing, and beginning to discuss if this situation are acceptable in a EU law in the case of media. Seems to me that here the lex specialis angle is an addition for the future in a way. What do you think?
I totally agree, and I think it's a strong signal as well, because there are many other sectors where competition is a very efficient tool because it's extremely horizontal and flexible. We can put it in different sectors and just adjust it a little bit, but this has been left very much to the margin of discretion of the different authorities. And sometimes we have had discussion about competition for sustainability, competition for the environment, competition for non-discrimination, and so on and so forth. Here, the signal is much stronger. Here, we have written into a text that when it comes to the media sector, there are other values and other objectives that are at least as important. So I think that is a sort of a full endorsement of this margin of maneuver that traditionally, potentially, regulators could have had in any case, and it's also a nudge into a specific direction. So I see this as an opportunity, and I see this as an encouragement to do more. Having said that, my comment about the scope of application is also an issue very linked legally to the legal certainty principle. So this margin of maneuver need to have some boundaries. Otherwise, we run the risk of putting actors in a situation where they don't know when and if that kind of assessment or that kind of objectives will come into the assessment. And so this is not going to be, as you pictured the scenario at the beginning, it's 27 member states with different level of sensitivity, different regulatory frameworks at the moment. So I think for legal certainty, we need to establish the scope in a much clearer way. But yeah, I'm not even sure that it would be good to sort of have this level of certainty in, sorry, to put the same line in the different states, but just to sort of allow for some mutual learning for the for the first couple of years, maybe a good solution here.
Okay, thank you, Maria Luisa. And we move to the next speaker, that is Frederick Bobkowca from Arcom. So we have a regulator finally coming in.
Yes, thank you, Pierluigi. Good morning, everybody. Hope you can hear me well. Thanks a lot for the invitation. First of all, it's always very interesting for us national media regulators to be part of these talks with our head of national regulator and with our second head of media board members. So what I would propose you now is to update you on where is the media board regarding this issue. Since, well, as you all know, the Media Board has the task pursuant to Article 22(4) and Article 23(1) of EMFA to, in certain condition, issue an opinion on the media market concentration likely to affect the functioning of the internal market for media services. And when it's under Article 22, that is to say, when the Media Board is requested to provide such an opinion by a national regulatory authority, well, the NRA, the national authority, then shall take the utmost account of the opinion. So it's only an opinion that the board delivers. It's not a decision, but it's an opinion to be taken into account. And then Article 23 comes where, in situations where, for a reason or another, there has not been an opinion delivered under Article 22, but the Media Board may, by itself, on its own initiative, or at the request of the Commission, draw up an opinion on a case. So the Media Board regarding this has led essentially until now a preparation work. As you know, there has not been any request for opinion so far, but we have done all we could do in order to be ready to handle any case, any request for opinion, well, as from the 8th of August, which is the date when the provisions entered into application. So what we did was basing ourselves on the text, of course, of EMFA and its recitals, but also on all the available corpus of jurisprudence and various legal texts, as well as our own national experiences. We've been drawing an internal document which is going to serve ourselves as a guidance whenever a case or cases will come to us or will be likely to come to us. So this is an internal document, obviously, but I can share with you, well, what it covers. Well, basically, the intent is really to clarify as much as possible which factors are foreseen to trigger the procedure of giving an opinion, and then how the assessment for the opinion itself shall be made by the board. So it means that first, on the preliminary phase, we've tried to clarify as much as possible our idea of what is a media market concentration, of course, relying on, well, EMFA, on the EU merger regulation as well, and on the relevant Commission consolidated jurisdictional notice regarding this issues of notions of concentration. We've also worked on, well, definitions, media service provider, and online platform, because this is something notable, and as Ricardo also underlined, that obviously, online players, online platforms do have an important, more and more important role in access to media and in media pluralism. And it's true that EMFA certainly won't solve everything in this regard, but it's notable still that the Article 22 covers concentrations both in the media service providers range and in the online platforms range, which for us makes really much sense. So this is something obviously we are taking into account. And if you allow me a brief parenthesis on this, Yeah, certainly it's not enough. There are also other provisions in EMFA to tackle the role, the important role online platforms play in pluralism, media pluralism, and I think especially about Articles 18 and 19 on the so-called media privilege. And obviously there are also other provisions in the Digital Services Act, especially for very large online platforms or search engines, which could also be leveraged on when trying to tackle this very important pluralism issue in the online sphere. I won't expand more on this, but okay, there are hooks here and there. Obviously, now the important thing is to actually seize them. So to come back to what we've conducted, So first, what is there a media market concentration? Then is it likely to affect the functioning of the internal market, which in itself is an interesting question. We have recitals, obviously, in the regulation, giving some examples, which are not exhaustive. So we've tried to elaborate our thought based on these examples, and especially on criteria, which are relevant criteria on market shares, on audience reach, on level of circulation. And here, well, we see that we have a challenge, which is that depending on the types of media that we are talking about, it's very difficult to have a unified and consistent matrix across the different media when trying to approach, in fact, the impact they have on the formation of the public's opinion. So that's one of the challenges we've pinpointed and we'll have to deal with anyway. But that's something really necessary when approaching this issue of the impact of a merger or of a concentration on the formation on the pluralism and also on the functioning of the internal market. And maybe also a parenthesis on this, we've been trying to think about, is it possible to set quantitative threshold for these elements? It's not in the text, obviously, for a good reason in the EMFA text. We've refrained from doing this at this stage, and I have to say it would be extremely difficult also for the reason I was mentioning, to just only to achieve a common matrix on what we're talking about. And to add something, also nationally, actually, this is something that is not so easy to approach. And as Maria Luisa was saying, we have to deal with the fact that a part of the solution, a part of the scheme is to be built by 27 different member states, and that was a very crucial part in the deal of EMFA itself, to rely on subsidiarity to a certain extent. And well, this question of approaching the impact of media on the pluralism and setting quantitative thresholds is a challenge that actually all member states share, as well as us at the Media Board at the European level. So I covered the preliminary assessment questions. Is there a media concentration? Is it likely to affect the functioning of the internal media? And then there is a third aspect that we've tried to cover, which is, well, then the assessment itself. Could this concentration operation have a significant impact on media pluralism, on editorial independence? To approach this, we obviously relied on also indications we have in the text. Of course, it starts with the impact on media pluralism itself. And here we looked at different configurations like horizontal concentration, diagonal concentration, vertical concentrations. Sometimes we have mixtures of all these, and they are likely to have various kinds of impacts on the pluralism at the end of the day for the European citizen. We as well looked at the question of safeguards for editorial independence. We have a number of indications given here again by a recital of the regulation. And this is actually pretty linked to the third item, which is to be taken into account, which is that of the economic sustainability. And here I would like to completely endorse what Ricardo said. I mean, we have to take this into account, because if we don't, we may very well end up saying, no, this is bad for pluralism, but then the media concerned is dead. So it's obviously not better for pluralism. It's obviously not better for the European citizen, and also not for the employment. So yes, we are in a situation where, in fact, there is a systemic problem of economic sustainability for media, and especially, as was stressed, local media, which are the most fragile ones, be it press, be it local TV, be it local radios. And certainly, I mean, EMFA cannot solve this problem by itself. EMFA brings some solutions, some very partial solution, but there is a need also for the broader issue of financial sustainability, and there is a need for financial for financing, actually, and providing for more financing for independent media, for independent journalists. And we really hope, that's also another parenthesis, we really hope the Commission takes this into account when going forward with the European Democracy Shield. For us, it's really a crucial point. And to come back and finish on what we've covered, so safeguards for editorial independence versus economic sustainability, also taking into account the Commission's annual rule of law report, which is something that in some cases can give an indication on, well, the media markets at stake, and then the commitments offered by any of the parties involved, also very closely linked to the safeguards that can be obtained for editorial independence. So this is, well, very quickly presented what we've tried to cover in this, again, internal guidance document that we have developed before the summer. All this is obviously only preparatory work, meaning that this is only a guidance, and obviously then the interesting part comes when we have real cases. And so really, this is something that can only be assessed on a case-by-case basis. We have to confront our initial document to these concrete cases, and certainly our initial document is only a first initial version that will have to be updated then on the building on our experience. Just to conclude at this stage, what is important now also for us is, even before, I mean, a case would just come on the plate of the media board, is to internally exchange on this. So this is really something that we are doing. We actually have a meeting tomorrow where we'll be precisely exchanging amongst media board members on potential cases, on situations, I mean, national situations and potential cases that may arise, that may be considered as well, triggering a request for opinion for the media board, so that we already, well, start having a sense and exchange of how we could handle this. And to finish on this, one very important thing to be noted is that at this stage, as you are aware, well, in a quite significant number of member states, there is not yet any designation of the national authority that is in charge. In various cases, there is a suspicion that such or such will be in charge, but it's not yet designated, which means that this could, at least at this stage, to some extent impair the capacity for a national authority to request an opinion pursuant to Article 22(4) of EMFA. And this is also something that we have to take into account within the media board when approaching certain cases that are now presenting themselves. So, well, this is a bit where we are. Just to conclude, to tell you how much, I mean, at the media board, we see this provision as a central provision of EMFA. for pluralism, for the interest of public, so that it can form its opinions. And not only this, that's the main point, but it's also about the educative role of media. It's also about its cultural role, as was mentioned. So we are, well, definitely ready to take our role there, and certainly soon to be started. Thank you.
Thank you, Frederick. Just one word more. I see that you are preparing, in a sense, from what you are at the board there. But are you also trying to, you mentioned it, but I wanted to hear some words more. Are you preparing about this thing of using editorial independence as a remedy to some preservation, some structural preservation of editorial independence as a new remedy when in cases like the one you were mentioning, in which the only choice is because of sustainability to let the merger go? Are you trying to elaborate also considering the difference between countries and member states and their culture about editorial independence?
Yeah, absolutely. And again, this is a point, as you say, where yeah, the variety of situations among the 27 member states plays an important role. Yes, we've tried to really go a step or two further than just saying, okay, well, safeguards for editorial independence have to be considered, and in our common document, this internal guidance document I was mentioning, which has been adopted by the media board. So we found agreement amongst the members of the media board on this document. We go further and envisage well, what kind of safeguards for editorial independence may be envisaged, of course, depending on cases. So conscience clauses, the right to leave and retain applicable benefit if the ownership changes and it's believed to threaten editorial independence and integrity, ethics committees. Okay, I won't enter into details, but so these are at least, you know, a number of points which we listed and which we agreed upon amongst the media board members as being relevant to be considered in the course of the evaluation of such an operation. Of course, now this being said, when it will be about a real case, then there might also be differences of appreciations, not to mention the differences in national frameworks. But yes, this is really something that we are all convinced makes sense, at least on the principle, to be taken into account, precisely because we know that we are going to run into situations where the economic sustainability will prompt for going for the merger, but then trying to lessen as much as possible their impact, both on the public and on the journalists and employees of the media outlets concerned.
Thank you, Frederick. Okay, last but not least, we have Matt Kozak from Utrecht University School of Law, so one of the important center of attention about the evolution of the media pluralism and the EMFA. And also, Margot has personally, from what I understand, has been personally involved somehow in the Dutch case, so that's interesting also to hear. You have the floor.
Good. So no, it's already good afternoon, everyone. Thank you, Pierluigi, Elda, and Roberta for including me, and thank you for organizing this very interesting event. I will be discussing the merger control. I mean, more than EMFA really. My discussion will actually refer to the opinion that we drafted together with Professor Anna Hebrandi within the scope of the merger that has already been mentioned a couple of times. And you can see already by making also reference to what Pierluigi said at the beginning, we started from the assumption that media companies cannot be treated as just another business. And I would like to make, before I start, some disclaimers. So this opinion is an academic opinion, and so we did not discuss the factual setup of the case. Also, we did not have access to the case file. And the opinion was finalized in March, so before EMFA's obligations became binding. And therefore, there is a chapter there about an obligation of conform interpretation. Though I think it's will be still relevant as far as I know, the Netherlands hasn't still implemented EMFA. So the obligation is even more binding, let's say, in place now. Our implicit assumption is also that the specific case we are in the specific case we are in the presence of an independent authority. I will come to that at the end, also referring to what, because Maria Luisa mentioned Polish cases. So, and I think this is a question or an issue that is not being discussed together with EMFA setup. And then the presentation and the opinion is devoted into questions related to competition law, democracy, and media pluralism specifically. So I made the presentation because I thought it would be easier to discuss it and to structure the discussion. So, and I will very briefly discuss questions about media pluralism in European law, because I mean, there are better experts here in the room, of course. The definition of media pluralism, what are the competition law concerns, power, because we are discussing here really different emanations of power. Whom are we talking about, citizens, consumers, or both? And then the theories of harm under competition law. And I mean, Ricardo already discussed the transaction, so we are discussing the acquisition of RTL Netherlands by DPG Media. DPG and RTL were major competitors on the news market in the Netherlands. DPG published various newspapers and also owns some free news website, whereas RTL Netherlands has several commercial television stations and offers video streaming service, and also offers some free news through its television channels, website, and a specific app. So you can see the transaction, the source of this graph is the website of the ACM. Now getting to the core of the problem, of course, media pluralism, we know, stands as a cornerstone of democratic societies. We don't have one definition throughout the European Union. And also we have 27 member states. So EMFA is supposed to safeguard media pluralism. What it means still needs to be probably figured out. It's widely debated across political economic sectors. So our starting point in the opinion was really also to ask the questions, what are we protecting and how it should be taken into account within the assessment. And we discussed various definitions. I mean, of course, macro, meso, micro level, or content exposure and source diversity as well. Therefore, we used for the opinion, after having looked at media pluralism from those different perspectives, you see these are Jenga towers by my son, built a long time ago. We thought about access of citizens to a heterogeneity of opinions and voices through different media services and content as a starting point to catch actually all the questions that we are facing currently. And from this definition, we looked at media pluralism as competitional concern. So we know that media mergers suppress innovation, competition. They reduce incentives to produce diverse news. They lead to homogenization of content. And then there are specific cases discussed from Belgium, France, where actually commitment solutions to maintain editorial teams were put in place. And one of our argument is a bit against the mainstream in competition law, so that application of competition law goes beyond ownership in this case, and that lessening of each dimension of media pluralism actually is linked with competition law concerns, and then horizontal media mergers with market power impact newsrooms' independence, leading to lower diversity and equality, which can be seen as an equivalent to indirect price increase. In the opinion, we elaborated actually two ways of argumentation. So one is looking on the basis of classical, let's call it classical competition law analysis. And then we were also discussing the new theory of harm. I will get there in a moment. I think our focal point was also that in a case where the merging companies are news providers, so when we are in the presence of quality journalism, merging through this concentrated ownership, so newsrooms, news titles, there must be a very high degree of substitutability. So that could lead to a higher likelihood that also the news content can become homogenized. And then we used an analogy with the SIEC test. So if the combined market share normally is large, the likelihood of SIEC increases. So when the merging firms are close competitors with highly substitutable products, the risk of producing SIEC is even more pronounced. So SIEC, for those who are not competition lawyers, this is one of the major tests crucial for merger control. And then, so we are getting, of course, to questions of power, and this is Anna's research, but also Claudia Mayhurst's. There are different emanations of power. Currently we see the increase of opinion power, and opinion power is not completely kind of a substitute or similar to market power. And opinion power is, of course, part of the concept of media pluralism. So how they relate to each other. And this is a bit like a three-body problem, you know, if you recall the moons from the book. At the moment when they overlap, we consider that then it becomes also a competitional problem. And to give you the example, that was Maciej Bernard's example from his book, we can have a network of restaurants with a very high market power, but they have no opinion power. On the other hand, we can imagine a person or a company with a very high opinion power, but having very little market power. So in fact, this moment when the Venn diagram starts to overlap, this is where we are facing an issue, and we argue in the opinion that this is where also competition law, so that the competition law analysis can take over into account and they can take into account the opinion power analysis. We also discussed the question of consumer welfare, and you know, this is one of the most debated concepts also in competition law. Of course, media markets, as I said, are concerned with the public sphere, with the opinion formation and the limits of the market, but media consumers are also citizens. So, and not all citizens are direct consumers of media. So but then here is that if we have only even smaller group concerned, then this is such a commodity that it starts to reach citizens and influences their choices. Therefore, the harm which is caused by decreasing pluralism falls on citizens regardless of their consumption. And that is a question or an issue that should be taken into account by the competition authority. And then we also discussed the theories of harm, because this is like the key of the competition law analysis. So as I very briefly showed, we talked and we tried to prove that that decreases across different levels and facets of media pluralism can lead to classical harms, so quality, innovation, diversity. But those can also lead to decreased pluralism, which of course threatens the process of democracy. And then this brings a distinct type of harm. And here we refer to the quality journalism and this homogenization of content from merging newsrooms. And we conclude that actually those different ways of argumentations, because of course I was very brief, the document has over 40 pages, that they are not exclusive. So they reinforce each other, and they should be really seen as strengthening media pluralism. And here I would like to make a reference to what Maria Luisa said. Why do we need EMFA then, if we could if we could use competition law? This is also I think, legitimacy question, because if we tell competition authority, look, you need to look into media pluralism issues. Of course, we saw the discussion, for example, with data protection. There is a question, okay, on what basis? Is it really within our remit? And this is how I think that could strengthen the arguments that media pluralism is relevant for competition authorities. But, and this is a very strong reserve on my side, this is it can also be two-sided weapon. So we saw it in Poland with some cases, and this is also why we need to talk about independent authorities. So thank you very much, and yeah, I hope it's, yeah. I stop sharing. Yes, that's.
Yes.
I know, stop sharing.
You are still.
Yes.
Yeah. You still didn't get out.
Am I still?
Yes, nowadays.
Okay.
Thank you. Thank you, Gonzalo. One thing I wanted to ask you is this was the study was presented before the decision, obviously, in the case. How was, particularly in the remedies, was this? Do you feel that your ideas were somehow vindicated in the attempt of the remedies in the limits of what academia can?
I would like not to review the decision, and I wouldn't feel very comfortable to kind of make a review on it. However, I must say that we had several exchanges with the ACM. We talked and we explained also our position in respect to media pluralism. And we were also very independent. So that was very clear that this is what we want to write, and this is what we want to kind of be very explicit about. Yes, so I would put a full stop here and not review the decision. But I mean, but the commitments are extensive if you look at them from the perspective of the outcome, the ultimate outcome, and how the authority approached the whole issue.
Okay, thank you. Well, we have around 10 minutes for questions. I see already one first question in the chat. Please go ahead with the question. Let's say this, put a question in the chat. Also, the speakers can have a look at them, and then we will go with a quick round of the speakers answering to them. I see that the first one is about if a large EU-based public financial large online platform existed, providing job as channel to reputable media journalists, if this could be a contribution. That's something the discussion is beginning. Another question is, by the way, this was about from Albin, Siberia. Then Anna Ferrari is asking, do you foresee some media mergers might be approved or rejected by a national competition authority, and vice versa, the idea that there could be a contradiction between the two decisions between competition and the media authority? That obviously is an interesting question for this idea that there is a double check. Then Luigi Malferrari would like to ask Maria Luisa about the relationship between Article 22 and the merger regulation, please. Then I see Maria Luisa, but I give to Maria Luisa the floor later as speaker. Let me give the floor to Roberta. Roberta.
Thank you. Thank you, everybody. It is a very, very interesting talk. So I want just to raise an issue about, I'm very worried after this conversation about the situation of local media, because many of you stressed this risk, and they risk to these concentrations that we are seeing everywhere in Europe, risk to go underlooked, because I mean, it is not on the European Media Board because these are not concentrations that are relevant for the internal market. But it is on the national law to include this local concentration in the scope of the media plurality test. But if they don't, who is going to decide that these laws implementing Article 22 are not enough? So I wanted to also to highlight the fact that among the criteria of Article 22, there is one that has not been mentioned by our speaker. That is that in the assessment of the test, the interests of the parties in other businesses that are not media related must be taken into consideration. This is, in my opinion, important in general, but specifically for local media because we see more and more, I'm sure of this in Italy, but maybe also in other countries, local businesses saving media just not to save their economic sustainability, but just to have a way to control the public opinion of local level and to defend their interests. So my question for all the speakers is, first, how can we apply Article 22 to local media? And second, if these criteria of the owner's interests that are not pure publishers, that are not related to media, shouldn't it be more considered in assessing, in implementing the media plurality test?
Okay, let me add that Elda rightly signal to the question of the possibility of a wide broadcaster and so on. She signaled our study on European news streaming platform that has been finished a few months ago. It's somewhere on the subject. We signaled the study. Then there are a couple more questions for the speakers. Do you think that media pluralism should be assessed with regard to increased competition to large online platforms and now compete in artificial intelligence product? And another institutional question from Anna, sorry, this was by Aurora. And Anna Ferrari, a second question, how strong will be the opinion of the media board? If after the opinion issue, the national authority decide differently, might some lawyers use the opinion to litigate in court against the decision of the national authorities? Okay, I think we have a certain group of questions, and I would give the floor again back to the speakers. You can pick choosing from your own preference and closeness to the question, but you have a couple of minutes each for answer. I would start in reverse order, so Margorzata, you can start.
Yes, thank you very much. So I would like to tackle or to get to the question about the relationship about between EMFA and merger control. I think it's a very relevant question, especially in the light of EMFA specification that this assessment is separate from competitional assessment. However, I still think that there is place for both, and that actually we need both, because then it makes it means that the system, also that the assessment will be much more complete and much more thorough than if we only rely on EMFA test. Also, please note that EMFA test is not obligatory. So this is also a question how in different member states the opinion or the EMFA test will be used by the parties, and how actually what competition authority will do with it. So to give you an example, I'm also one of the founder of an NGO in Warsaw, and we, together with 7 other NGOs, we gave our opinion in EMFA legislative process in Poland. And there was a really vast discussion about what should be actually the result of the opinion. Is it binding on competition authority? And then we heard from some media companies that that will be a disaster, because if let's assume that the opinion is negative, what happens then? So our advice in the Polish context was really to leave it non-binding. However, in case the competition authority deviates from the opinion of the media supervisory authority, and then, in Poland, there is a political capture of the media supervisory authority. So there is really a bigger problem behind. Then competition authority, in case of deviation, must provide a justification to this, and the opinion must be part of case file, so that the court could at least assess to what extent the opinion was justified and the position of the competition authority was justified. However, we didn't advise for two separate procedures, because that would be also overburdening for businesses. So that's my intake on the relationship between EMFA and merger control.
Thank you. Fredrik, these are topics that are also close to your role.
Yeah, thank you very much. Maybe I'll pick up a few of them, but quickly. Yeah, on the question in the chat of Elda on should a large EU-based platform be put in place and, in fact, handle what we are looking for in terms of plurality and the very place for the media on these platforms. Of course, my answer would be a big yes if we manage to do so. Yet, I would say that this is something that probably doesn't emerge so quickly. Also, in terms of the place it has in the public usage. So I think we also have to try to enforce more pluralism on the platforms that are in the place today, which are, well, usually for the biggest one, not European, unfortunately. And for this, we already have some tools. We already mentioned the media privilege in EMFA, Articles 18 and 19. There is also in the Audiovisual Media Services Directive, which is, of course, only for audiovisual media services, but we have this services of general interest provision, which also intends to be a partial answer to this concern. And we have the Digital Services Act, where we have, under the systemic risks, I think the issue of pluralism and of balance in handling the various opinions and giving access to media content and a variety of media content may also be addressed. So we have some tools, and if we a part of our reflection now is also in the contributions we're making to the Commission, is whether some of these tools should be reinforced in further revisions. So that would be another facet of the answer to this question by Elda. Very quickly on the relationship between competition and pluralism or EMFA appraising, I would really agree with Małgorzata that they should complement each other, that. Okay, I wouldn't take any position on whether the media assessment should be binding or not. Well, in fact, it's again a matter for national legislators. But I would just say that whatever the case is, it is of common interest that the competition authority and the media authority are very tightly in contact, so that they avoid as much as possible any discrepancy. And then, sorry if I'm being a bit long, I think there was a question specifically in the chat on the decisions of the media boards. And yeah, I agree completely with the solution proposed in the chat. The point is that the opinions of the media board are not binding, but the regulation says that they should be taken into account and then even shall take utmost account of the opinion that is issued by the media board, so that if it's not the case, or if there is not a sufficient reason that is invoked not to take into account the media board opinion, this may then be used in court if need be by any interested party. So that's really the way we see it. Thank you.
Thank you, Frederick. We are at the end of time, but we can go 5 minutes more. But let's stay in the 5 minutes. Maria Luisa.
Thank you. I'll try to be as brief as possible, so I won't repeat things that I just endorse. But coming backwards, so for the opinions, I think my point is it really depends on how the board and the system will develop. If there is a lot of trust in between the national authorities and the board, then a binding opinion is going to be perceived in a completely different way than if there is no trust. And then the national authorities will keep thinking that for the local specific needs, they should take the final decision. And I think the tension there is something that can be sort of smoothed by working on the system. I like to sort of be a little bit more provocative on the idea of a EU-backed large online platform. I see the point, and there are so many merits on this idea. There might be one strong pushback, which is if we have a problem of concentration and dependency, is the answer to a problem of concentration the idea of having yet another very large player that becomes a must go-to? Maybe we can work on nuances and we can say this is just a platform, and in this case, just on this case, differently from what we have now, the users will have autonomy and independence, and they will have choice. If this premise might be, guaranteed, then the idea of having yet another giant platform might sort of be presented in a different way. But otherwise, we're just, trying to fix a concentration problem with a concentrated actor. Just as I said, to be provocative. There was another question by Labo, which I think is extremely interesting, and it probably would deserve a little bit more elaboration. But one key point only there is indeed, AI and cloud are completely changing not only the platforms that we had since 20 years. Those have changed the distribution issue, but the distribution part. What we're talking here is a massive impact on the production part, the production environment. And I think there is some research finally on this specific point that deserves all the attention about how the cloud infrastructure and the AI adoption is changing the production of news. The Council of Europe has put a couple of years ago these guidelines about the journalistic AI and presenting it as an editorial decision. And I'm absolutely convinced it is an editorial decision. So we need to work on this. But as I said, quite a lot to elaborate. The instruments are there, but we need to be bolder and braver, I think.
Thank you, Maria Luisa. Riccardo.
Thank you, Pierluigi. Very briefly, several questions concern the overall economy of the European media ecosystem. And this is really a key issue, as Frederick said. Well, I don't know if it's possible to create a public European online platform based on non-profit, on public interest. Which European player today is capable of competing with Google or Meta? I don't know. What is certain is that independent media, independent journalists must be recognized more than ever for their role in the public interest. I would say this requires public funding for media actors, and this could take the form, for example, of a tax on big tech businesses. It also requires stricter rules to protect journalists' copyright and make platforms pay for their use of editorial content. Public funding for media is truly crucial. You know that Renato is fighting with others regarding the MFF, the EU budgetary framework for the coming years. We really need to increase the financial support for the media.
Thank you, Riccardo. Let's conclude in a second. While I'm in favor and interested to the idea of the European platform with the caveats probably that Maria Luisa was mentioning, and I'm also, and I've written in favor of media support, public support in certain circumstances with all the necessary attention. I don't want to conclude on this. I want to instead conclude on a different one, more seems to me more connected to the discussion of today. And my suggestion is that we explore in a deeper way what is the space that Article 22 is opening for the media sector and for the media. I'm all in favor to coordination with competition. I always like the competition, and so I understand this power and this usefulness, but I think this is the moment to explore what 22 can give to the media sector. And then we'll see how to combine the two things and the other protection, and how to cross-fertilize among the two words. Seems to me that this should be really the next step. But anyway, it was a fascinating discussion. I've learned a lot. Thank you, everybody. There was a very high participation. I think these EMFA talks are a success, and I think this success can continue in the future. Thank you very much to all the speakers, the participants, and the organizers. Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye.
Thank you.